Hello everyone, my name is Lakshmi Priya. In the last class, we have dealt with right against exploitation and right to freedom of religion. In today's session, we'll deal with cultural and educational rights, that is Article 2930, and next constitutional remedies, that is Article 32, and the rest of the articles of fundamental rights, that is Article 33, which deals with armed forces, Article 34, which talks about martial law, and Article 35, which includes the provisions that are affecting the fundamental rights. Okay. First, let us see about cultural and educational rights, that is Article 29 and 30. Protection of interest of minorities. Article 29 provides that any section of the citizens residing in any part of India having a distinct language, script or culture of its own shall have a right to conserve the same. Okay, Article 29, it mainly talks about the protection of interests of minorities. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste or language. Okay, no citizen shall be denied admission into any educational institutions that are maintained by the state or receiving the aid out of the state funds on grounds only of religion, race, caste or language. Okay, no citizen shall be denied admission only on the grounds of religion, race, caste or language. Next, the first provision protects the right of group, while the second provision guarantees the right of citizens as individuals. Okay, the first provision, it protects the right of group, while the second provision guarantees the right of citizen as individuals. Okay, next. Article 29 grants protection to both religious minorities as well as linguistic minorities. Okay, minorities related to religion and minorities related to language. It gives protection to both religious minorities and linguistic minorities. However, the Supreme Court held that scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. See, here Article 29 grants protection to both religious minorities and linguistic minorities, but Supreme Court said that it necessarily not restricted to minorities only. That means it can be extended to others as well. Okay. Next, the Supreme Court also held that right to conserve the language includes right to agitate for the protection of language. Supreme Court also said that right to conserve language includes right to protection of the language. Next. Right to minorities to establish and administer educational institutions. Article 30. Okay, it grants the following rights to minorities, whether religious or linguistic. All minorities shall have the right to establish and administer educational institutions of their choice. Okay, Article 30, under Article 30, it says that all minorities shall have the right to establish and administer educational institutions of their choice. Next, the compensation amount fixed by the state for the compulsory acquisition of any property of the minority educational institution shall not restrict or abrogate the right guaranteed to them. Okay, see, the compensation fixed by the state. Okay, the compensation fixed by the state for acquisition of any property for the minority educational institutions, it shall not restrict the rights guaranteed to them. Okay, that means the amount which is fixed by the state, it should not restrict the rights guaranteed to the minorities. This was added by the 44th Amendment Act of 1978 to protect the rights of minorities. Okay. Next. In granting aid, the state shall not discriminate against any educational institution managed by the minority. While granting the aid, the states are not allowed to discriminate any educational institutions managed by the minorities. Thus the protection under Article 30 is confined only to minorities and does not extend to any section of citizens. Okay, Article 30 is purely for minorities, either religious or linguistic minorities, but it does not extend to the section of citizens. Okay, next, however, the term minority has not been defined anywhere in the Constitution. Though we are talking about minority, see, the term minority is not defined anywhere in the Constitution. Next, the right under Article 30 also includes the right of minority to impact education to its children in its own language. See, Article 30 also says that minority sections can also include the education to their children in their own language. This was included under Article 30. Next, what are minority educational institutions? See, there are three types of minority educational institutions. First is institutions that seek recognition as well as aid from the state. Aid is nothing but help. Okay, institutions that seek recognition as well as aid from the state. Next, institutions that seek only recognition from the state and not aid. This is second type of institution. Next, institutions that neither seek recognition nor aid from the state. So these are the three types of minority educational institutions. Next, Article 32, that is right to constitutional remedies. This Article 32 is important. Okay, let us see. Article 32 confers the right to remedies for the enforcement of fundamental rights of an aggrieved citizen. In other words, the right to get fundamental rights protected is in itself a fundamental right. Article 32 gives right to the remedies for the enforcement of fundamental rights of an aggrieved person. Article 32 itself is a fundamental right. Okay, Dr. B.R. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is a very soul of Constitution and a very heart of it. Okay, Article 32 is a very soul of Constitution and a very heart of it. Next, the Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away by the amendment of the Constitution. Okay, Supreme Court said that Article 32 is a basic feature of the Constitution. That is, as it is said as a basic feature, it cannot be amended by the Parliament. Okay. Next, it contains the following four provisions. The right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental right is guaranteed. Okay, first is the aggrieved person can move to Supreme Court if his fundamental rights are violated. Okay, next, the Supreme Court shall have a power to issue directions or orders or writs for the enforcement of any of the fundamental rights. Supreme Court has a power to issue the directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may be include habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Okay, these five are the writs issued by Supreme Court. Next, Parliament can empower any other court to issue directions, orders, and writs of all kinds. See, Parliament has a power to empower any other courts to issue the direction, orders, or writs of all kinds. Okay. Next, the right to move to the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. See, the right to move to Supreme Court shall not be suspended except otherwise provided by the Constitution. That is, Parliament has the power to suspend the rights of aggrieved person to go to Supreme Court if if his fundamental rights are violated. Next, thus the Constitution provides that the President can suspend the right to move any court for the enforcement of fundamental rights during the national emergency. See, Constitution provides that President can suspend the right to move to any court for the enforcement of fundamental rights during national emergency. That is Article 359. So constitution says that president has the power to suspend the right to move to any court for the enforcement of fundamental rights during national emergency. If there is any national emergency, then president can suspend the individual's right to move to any court for the enforcement of the fundamental rights. Next, the Supreme Court has been constituted as a defender and guarantor of the fundamental rights of citizens. Okay, Supreme Court is a defender and guarantor of fundamental rights of the citizens. Next we'll see writs. Okay, very important. Writs. Supreme Court under Article 32 and the High Courts under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. Supreme Court and High Court. Supreme Court under Article 32 and High Courts under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. The Parliament under Article 32 can empower any other court to issue writs. Not only Supreme Court and High Court, Parliament can empower any other courts to issue the writs. Since no such provision has been made so far, only Supreme Court and High Court can issue the writs and not any other courts. See, though the Parliament has a power to empower any court to issue the writs, but so far it has not done anything like that. So only Supreme Court and High Court has the power to issue the writs. Okay, next, Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law, where they are known as prerogative writs. Okay, under English laws, these writs are called as prerogative writs. Next, the writ jurisdiction of Supreme Court differs from that of a High Court in three respects. What are they? The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas the High Courts can issue writs not only for the enforcement of fundamental rights but also for the other purpose. Okay, Supreme Court can issue writs only for the enforcement of fundamental rights, whereas High Courts can issue the writs not only for the enforcement of fundamental rights but also for the other purpose. That means, in case of writs, High Courts have the broader sense than Supreme Court. Okay, High Courts have the broader sense than Supreme Court. Next, the Supreme Court can issue writs against a person or government throughout the territory of India, whereas High Courts can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only and outside its territorial jurisdiction only if the case of action arises within the territorial jurisdiction. Okay, Supreme Court can issue writs against a person throughout the territory of India, whereas High Courts can issue the writs to the person only within the territorial jurisdiction. Okay. Next, a remedy under Article 32 is in itself a fundamental right, and hence Supreme Court may not refuse to exercise its writ jurisdiction. Okay, the remedy under Article 32 itself is a fundamental right. So Supreme Court cannot refuse to exercise its writ jurisdiction. On the other hand, remedy under Article 226 is a discretionary. So High Court may refuse to exercise its writ jurisdiction. Understand? Article 32 is itself a fundamental right. So Supreme Court must exercise its writ jurisdiction. Whereas under Article 22 it is discretionary. So High Courts may refuse to exercise its writ jurisdiction. Next, habeas corpus. Now let us see the writs one by one. First one is habeas corpus. It literally means to have the body of. Means what? See, if a policeman arrests a person, okay, if a policeman arrests a person, okay, he's police, he arrested a man. See, his family members, they doesn't know where the person is. Okay, his family members can move to court. Okay, these family members can move to court and ask where the person is. Then court orders police to show this person. Okay, this is the example for habeas corpus. It literally means to have the body of. It is an order issued by the court to the person who has detained the other person to produce the body of the latter before it. Okay, here court can ask the police to produce this person in front of the court. The court then examines the cause and legality of the detention. Okay, then court decides. It asks for the what are the causes and legality of the detention. Okay. Next. It would set the detained person free if the detention is found to be illegal. Okay, if this person is arrested illegally, then the court can detain the person free. Okay, next, the writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ of habeas corpus can be issued against both public as well as private individuals. The writ, on other hand, is not issued where the detention is lawful. Okay, if this person is arrested lawfully, then the writ cannot be issued. Next, the proceedings is for contempt of the legislature or court. If he is arrested under the contempt of court, then also his writ power is not issued. Next, detention is by the competent of court. Next, detention is outside the jurisdiction of court. If the detention is outside the jurisdiction of court, then also writ cannot be issued. Okay, next, mandamus. It literally means we command. It is a command issued by the court to the public officials asking him to perform his official duties that he has failed or refused to perform. See, if there is a office, public government office, okay, if any government official in that particular office is not doing the work, then court can issue a command to the public official asking him to perform his official duties. Okay, it can also be issued against any public body, corporation, an inferior court, a tribunal, or government for the same purpose. Not only the public office, but also a corporation, inferior court, tribunal, or government. Okay, it can be issued against all these members. Understand? Next. The writ of mandamus cannot be issued against a private individual or body. Earlier, habeas corpus is issued for both public as well as private. Right? Habeas corpus is issued for both public as well as private, whereas mandamus is issued only for the public, not for the private. Next, to enforce departmental instruction that does not possess statutory force. Okay, the mandamus cannot be issued to enforce the departmental instructions that does not possess statutory force. Next, when the duty is discretionary and not mandatory. If the duty is not mandatory, then also the mandamus cannot be issued. To enforce the contractual obligation. Contractual obligation is nothing but if a person is legally responsible for any contract agreement, then also the writ of mandamus cannot be issued. Against the president, next, against the president of India or a state governors. Okay, against president or state governors also mandamus cannot be issued. Again, against the chief justice of high court also mandamus cannot be issued. Next, prohibition. Literally, it means to forbid. See, it is issued by the higher court to the lower courts or tribunals to prevent the latter from exceeding its jurisdiction or upsurging the jurisdiction that it does not possess. Okay, if the lower courts exceed their jurisdiction, then high courts can issue the prohibition writ to the lower courts, telling them not to exceed its jurisdiction. Next, thus, unlike mandamus, it directs activity. The prohibition directs inactivity. Mandamus, earlier we have seen, right? Mandamus says the officials to do the work. If the officials are not doing their work, then mandamus says the officials to do the work. But here prohibition is, they say courts not to exceed their jurisdiction. Okay, not to exceed their jurisdiction. That means it directs the inactivity. Mandamus directs activity, that is, it tells the people to do the work. But here it is telling that not to exceed its jurisdiction, that is, it directs the inactivity. Next, the writ of prohibition can be issued only against judicial and quasi-judicial authorities. Okay, the writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against the administrative authorities, legal authorities, private individuals, or etc. It can be issued only against judicial and quasi-judicial, but not against administrative, legislative, and private individuals or bodies. Okay. Next. Next is certiorari. It means to be certified or to be informed. It is issued by High Court to lower court or tribunals either to transfer a case pending with the latter to itself or to squash the order of the latter in case. See, if the lower courts has given any judgment regarding any case, then High Courts can ask the lower courts to close the order issued by the lower court, or High Court can also ask them to transfer the pending cases which are with the lower courts. Okay, it is issued on the grounds of excess of jurisdiction or lack of the jurisdiction or error of law. If there are more cases with the lower courts, then certiorari is issued. If there are less number of cases with the lower case, then also certiorari can be issued. Or if there is any error in the judgment of the lower courts, then also certiorari writ is issued by the High Courts to the lower courts. Okay, thus unlike prohibition, this is only preventive. Certiorari is both preventive as well as curative. See, prohibition is only preventive, but certiorari is both preventive as well as curative. Next. The writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. Same as prohibition, right? Certiorari is also against judicial and quasi-judicial authorities and not against the administrative authorities. However, in 1991, the Supreme Court ruled that certiorari can be issued even against administrative authorities affecting the rights of individuals. See, in 1991, Supreme Court said that certiorari can be issued even against the administrative authorities affecting the rights of individuals. Like prohibition, certiorari is also not available against the legislative and private individual bodies. Okay. In case of prohibition, it is only issued against the judicial and quasi-judicial, whereas in case of certiorari, it is issued against judicial, quasi-judicial, and administrative authorities. Okay. Next, quo warranto. Quo warranto, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to the public office. Hence, it prevents the illegal usurpation of the public office by the person. That is, if any person takes the position by force or illegally, okay, then court can issue to inquire into the legality of the claim of the person to the public office. Okay, next, the writ can be issued only in case of substantive public office of a permanent character created by the statute or by the constitution. See, this can be issued only by the office created by the statute or by the constitution. It cannot be issued in case of ministerial office or the private offices. Next, unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Okay, this can sought not only by the aggrieved person but also any person who is interested in this. Next. Next, Article 33, Armed Forces and Fundamental Rights. Okay, Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of the armed forces, paramilitary forces, police forces, intelligence agencies, and analog forces. See, Article 33, it empowers the Parliament. Okay, it empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analog forces. The objective of this provision is to ensure the proper discharge of their duties and maintenance of discipline among them. Okay, Article 33 is main. The purpose of Article 33 is to ensure the proper discharge of the duties of the armed forces, military forces, and police forces, and to maintain the discipline among them. The power is to make under Article 33 is conferred only on the Parliament and not state legislatures. Okay, only Parliament has the power to make laws under Article 33. Any such laws made by Parliament cannot be challenged in any court on a ground of intervention of any of the fundamental rights. Okay. The laws made by the Parliament under Article 33 cannot be challenged by the court on any ground of contravention of any of the fundamental rights. Next is Article 34. That is martial law and fundamental rights. Article 34 provides for the restriction of fundamental rights while martial law is in force in any area within the territory of India. Okay, Article 34 talks about the martial law. It restricts the fundamental rights of an individual while the martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any court, government servant, or any other person for any act done by him in connection with the maintenance or restoration of order in any area where the martial law is in force. C. Parliament has given power to identify any government servant or any other person for any act done by him in connection with the maintenance or restoration of the order. Okay, when the martial law is in force. Next, the concept of martial law has been borrowed in India from the English common law. Okay, the martial law concept is borrowed from the English common law. However, the expression martial law is not defined anywhere in the Constitution. Okay, martial law is not defined anywhere in the Constitution. Literally, it means military rule. Martial law is nothing but a military rule. The martial law is imposed under extraordinary circumstances like war, invasion, insurrection, rebellion, riot, or any violent resistance to laws. Till now, martial law is not imposed. Okay, it is imposed only when there is a extraordinary circumstances like war, invasions, insurrection, rebellion, riot, or violence resistant to law. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. When the martial law is in force, the military authorities are vested with the abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of civilians, can punish the civilians, and even condemn them to death. Okay, when martial law is in force, abnormal powers are given to the military authorities. That is, they have the right on civilians. They can punish the civilians. They can even condemn them to death. Okay, next. Affecting certain fundamental rights. Article 35. It talks about the affecting certain fundamental rights. It lays down the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. Okay, power to make the laws or give specified fundamental rights are vested only with the parliaments and not with the state legislature. This provision ensures that there is a uniformity throughout the India with regard to the nature of those fundamental rights and punishment of their infringement. Okay, Article 35. It ensures the uniformity throughout the India in case of fundamental rights and punishment for their infringement. That is, if they are violated, then they can be punished. Okay. Next. In this direction, Article 35 contains the following provisions. Let us see what are they. The Parliament shall have the power to make laws with respect to the following matters. First, prescribing the residence as a condition for certain employments or appointments in the state or UTs or local authority or other authorities. Okay, this is under Article 16. Parliament has the power to make the laws prescribing the residence as a condition for certain employments or appointments in the states or UTs. Okay, this is under Article 16. Next, Parliament has the power to make the laws empowering courts other than Supreme Court and High Court to issue the directions, order, writs, and all kinds of enforcement of fundamental rights. Just now we have seen under Article 32, right? Parliament has the power to make any other court to issue the directions, orders, and writs. But so far it has not done. So only Supreme Courts and High Courts can issue the writs. Okay. Next, restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. Under Article 33, we have seen, right? Parliament has the power to make the law restricting or abrogating the application of fundamental rights to the members of armed forces, police forces, etc. Next, identifying any government services or any other person for any act done during the operation of martial law in any area. Again, this we have seen under Article 34. Next, Parliament shall have powers to make laws for prescribing punishment for those acts that are declared to be offences under fundamental rights. Okay, Parliament has the power to make laws prescribing the punishment for those who declare to be offence under the fundamental rights. Okay, next. This include untouchability and traffic in human beings and forced labour. See, Parliament shall have the power to make laws prescribing punishment for those acts that are declared to be offences under fundamental rights. Okay, they include untouchability, Article 17, and traffic in human beings and forced labour under Article 23. Next, any law in force at the commencement of the Constitution with respect to any of the matters specified above is to continue in force until altered or repealed or amended by the Constitution. See, any law which is in force at the commencement of the Constitution, at the time of commencement of the Constitution, okay, that laws can be continued until they are altered or repealed or amended by the Parliament. Okay, next. Rights outside the Part 3. Let us see some of the rights outside the Part 3. Besides the fundamental rights included in Part 3, there are certain other rights contained in other parts of the Constitution. These rights are also known as constitutional rights or legal rights or unfundamental rights. Let us see. No tax shall be levied or collected except by the authority of law. Article 265 in Part 12 says that no tax shall be levied or collected except by the authority of law. Next, no person shall be deprived of his property save by the authority of law. Okay, this was once a fundamental right but was removed by the 44th Constitutional Amendment Act of 1978. Okay, and was included in the Article 300A of Part 12. That is, no person shall be deprived of his property save by authority of law. Next, trade, commerce and intercourse throughout the territory of the India shall be free. This is included under Article 301 of Part 13. Next, the elections to the Lok Sabha and State Assembly shall be on the basis of adult suffrage, universal adult franchise. Okay, under Article 326 in Part 15. Okay, with this we are done with the fundamental rights. In the next class, we'll start with Directive Principles of State Policy, that is DPSPs. Okay, thank you.